Hi, I'm Bob Schindler, one of the education law attorneys here at Miller Johnson. And today I want to talk about administrator non-renewal. This is the time of year when this is becoming very important. And so I want to lay out the timeline and all of the things that we think about when it comes to non-renewal. One of the first things that we need to understand is that non-renewal, when we use that phrase, is different than termination. The phrase termination means the severing of employment during the term of an employment contract. Non-renewal means that an employment contract is coming to its end point, and we're not going to renew that contract or give an extension of that contract. Non-renewal is going to be governed by Section 1229 of the Revised School Code, where midterm termination of a contract will be governed solely by either the contract or a collective bargaining agreement. So when it comes to a non-renewal, Section 1229 creates certain timelines and requirements. The most important is that in order to non-renew an administrator's contract, they have to be provided notice of that non-renewal at least 60 days prior to the end of the contract. Generally, contracts will end June 30th, which means at least 60 days prior to June 30. But if the contract has a different end date, that's something to check and make sure of. So we have to provide notice of non-renewal at least 60 days prior to the non-renewal. And then 30 days before that notice, we have to provide notice of contemplated non-renewal. So the way this generally works is that we look back from the end date and we look to when our board meeting is at least 60 days prior to the end of the school year. So if we have a June 30th contract end date, we look for when our April board meeting is going to be. So let's just say, for the sake of example, that board meeting is April 24th. We then go back at least 30 days prior to that meeting and look at March 24th. And we provide notice of contemplated non-renewal no later than March 24th. That notice simply has to say that the district is contemplating non-renewal of the contract, give some basic reason as to why, and provide an opportunity for the administrator to meet with not less than a majority of the board and address the issue of non-renewal. So generally speaking, that notice will provide when the next boarding meeting is going to be and offer the individual an opportunity to address the board in that next meeting. That administrator's opportunity can be either in open or in closed session, depending on whether that administrator wants it to be in closed session, because that would be under Section 8A of the Open Meetings Act, which allows for an administrator to choose to be in closed session for the discussion. The vote on whether or not to non-renew would have to be an open session. And then the next day following that meeting, we'd want to provide that notice of non-renewal to the administrator. That timeline is very important because if notice is not properly provided under the statute says that the contract is automatically extended for another year. So we have to follow those timelines. Again, 60 days prior to the end of the contract and 30 days prior to that. It's really important that we think of it as 60 and 30 and not just 90 days, because if we just think of it as 90 days, we could be off on our 30 days prior to the actual notice. It's also important to understand that those are the statutory rights under Section 1229 of the Revised School Code. You are going to need to make sure that you check any employment contracts or collective bargaining agreement with an administrator or administrators group, because those could add more rights or additional timelines or additional notice requirements. And then finally, it is important to know that non-renewal can be done for any reason that is not arbitrary or capricious. That again is the standard set forth in the statute. Your Contracts may set out some different standard, especially for termination, but even potentially for a non-renewal. But under the law, it is an arbitrary, capricious standard if we're looking at non-renewing an administrator. So hopefully this takes care of any timelines and concerns that you may have when it comes to this issue. And if you have any questions, again, make sure you always let us know. Thank you.